All right, Wednesday. Donald Trump's money frozen. $180 million. Court documents just dropped yesterday. I've been going through the filings. Here's what I found. According to official court records, a New York judge locked down multiple accounts. Not suggesting, not warning, done. The mechanism? Banking systems most people don't know exist. 3 separate freezes, different institutions, same day. You saw the headlines. Here's what they missed. Quick context. Donald Trump, former president, real estate developer, currently facing civil fraud judgment. The issue? Enforcing a $454 million judgment from February's fraud trial. Timeline, fast version. February, Judge Engoron issues massive civil fraud penalty. March through May, Trump's legal team appeals, argues posting full bond impossible. June, appeals court reduces bond requirement. Trump posts $175 million. Last week, New York Attorney General Letitia James moves to secure additional assets. That's the setup. Now the documents. What most coverage missed. This isn't about whether Trump pays. It's about how you actually freeze assets belonging to someone with this kind of financial structure. Dozens of LLCs, multiple states, real estate holdings, business accounts, trust structures. Normal freeze order doesn't work. Yesterday's filing shows the specific banking infrastructure they used. Not typical, not simple. Let me show you. Okay, the evidence. First document, filed Tuesday. I pulled page 7. It says, quoting here, pursuant to turnover proceedings under CPLR 5225, the court orders seizure of funds held in accounts ending in 4719, 8834, and 2106. That's not my take, that's the filing. What it means? 3 different bank accounts, frozen simultaneously. But here's what got me. Page 14, different section, lists the banks. JP Morgan Chase, Capital One, Signature Bank successor accounts through Flagstar. Put those together? Yeah, multi-institution coordination. I went through this twice. Pattern's clear. Each account ties to different Trump Organization subsidiaries. Each freeze executed within 47 minutes of each other. All linked through New York's Uniform Commercial Code, Article 9, Secured Creditor Framework. All documented. Now, what nobody's covering. The filing references something called a post-judgment enforcement rider, page 23. It's a mechanism that lets judgment creditors access Federal Reserve's Fedwire system for priority holds. Read that again. That changes this. Most civil judgments, you file, wait, hope the defendant pays. They don't, you start seizing assets one at a time. Takes months. This, different path. When judgment exceeds $100 million in New York, creditor can petition for direct Federal Reserve notification. Banks get flagged in real time. Not common. I found references to it being used only 11 times since 2019. The specific language on page 23. Pursuant to emergency enforcement provisions, financial institutions with fiduciary responsibility are hereby notified through FR 2046 protocols. FR 2046, that's the Federal Reserve form that banks must comply with within 4 hours of receipt. 4 hours. That's why all 3 accounts froze within 47 minutes. Fallout. Trump Organization payroll account restricted. Real estate management account, restricted. Mar-a-Lago operating account, restricted. Within Tuesday morning. Here's the other piece. Page 31 shows they didn't just freeze checking accounts, they placed holds on sweep accounts. Sweep accounts, for those who don't know, automatically move excess cash into higher yield investments overnight. Most wealthy people use them. Money sits in checking during business hours, sweeps to money market at night. You freeze the checking account, money still moves. You freeze the sweep account, everything stops. The filing shows 8 different sweep accounts across 4 institutions. Total locked, the $180 million figure you're seeing in headlines. But wait, Trump posted $175 million bond already, right? Different pot of money. That bond came from insurance company backing. These frozen accounts, Trump Organization operating capital. What the Attorney General's office is doing, securing assets beyond the bond in case appeals fail and full $454 million comes due. One more thing from the documents. Page 47 lists anticipated future earnings from properties under management. They're calculating cash flow, projecting what Trump Org will generate monthly, preparing to potentially freeze future income, not just current balances. That's aggressive. That's just the first document. Subscribe. I'm not done. Multiple filings dropped. This gets more complicated. Okay, but look, got to be fair here. The other side has a point. Few points, actually. Trump's legal team says this is government overreach designed to cripple legitimate business operations. And honestly, some of it holds up. Their argument: first, Trump posted the required bond. Appeals court set it at $175 million. He complied. Additional freezes before appeal resolves violates due process. Second, these aren't personal accounts. They're business accounts, serving hundreds of employees, vendors, contractors. Freezing operational capital punishes innocent third parties. Attorney Alina Habba put it this way: this is targeted financial warfare against a political opponent during an election year. Don't agree with all of it, but that's not nothing. What they've got: bond was posted in compliance with court requirements. No precedent for additional freezes during pending appeals in civil fraud cases of this type. Even legal analyst Harry Littman, no Trump defender, admits the AG's move is unusually aggressive for a case still under appeal. Look, I'm not here to tell you who's right. Attorney General's interpretation: evidence supports legitimate concern about asset dissipation. Trump team interpretation: evidence of procedural overreach is there too. Both can be true. That's what makes this complicated. Here's their strongest point: timing. Why move Tuesday? Appeals process projected to take 8 to 14 months. Bonds already posted. What's the emergency? Trump's lawyers filed a response yesterday arguing selective enforcement. They point to other civil fraud defendants in New York with comparable judgments who faced no similar asset freezes during appeals. Case citations: People versus Hevesy, 2007, $5 million judgment, no freeze during appeal. People versus Rangel, 2011, $11 million, no freeze. Different scales, sure, but the principle: defendant posts bond, appeal proceeds, no additional seizures, held in those cases. Why different here? Trump team says politics. AG's office says scale and flight risk. What I can tell you, what the documents show, and they show both sides lawyered up with serious firepower, deploying legitimate legal arguments. Trump's got constitutional law experts arguing Fourth Amendment unreasonable seizure implications. AG's got commercial litigation specialists citing established judgment enforcement protocols. When you see that level of legal talent on both sides arguing opposite conclusions from the same statute, that tells you the law isn't clear-cut, which means judges have discretion, which means this comes down to one judge's interpretation of emergency enforcement provisions. And Tuesday, that judge sided with the Attorney General. But Trump's team has already filed for emergency stay with the appellate division. This didn't come out of nowhere. Backstory quick. 3 years ago, Attorney General James opens investigation into Trump Organization property valuations. 2 years ago, civil lawsuit filed alleging fraudulent financial statements inflated asset values to secure favorable loans. 18 months ago, trial begins. Evidence includes valuations for Mar-a-Lago, Trump Tower, golf courses, comparing claimed values to actual assessments. Someone even said on record, this is a clear-cut case of persistent fraud. What happened? Trial proceeded without jury at AG's request. Pattern? Trump Organization claimed property values. Independent appraisers provided different numbers. Discrepancies used to obtain better loan terms. Every time, banks didn't lose money, Loans repaid, no complaints from lenders. Until February. Judge Engoron issues ruling. $454 million penalty. Finds fraud occurred even without financial victims. Legal theory, fraud against the market itself distorts fair dealing. Trump's team argued no harm, no foul. Lenders, sophisticated parties who did own due diligence. Judge disagreed. Penalty included disgorgement of profits plus interest. Trump called it politically motivated persecution. A G called it accountability. Appeals began immediately. Bond fight followed, originally required to post full amount. Appeals court reduced to $175 million pending review. Posted April, seemed settled. Then, last week's Attorney General's office filed new motions. See where this is going? Hit like. Legal strategy shifting in real time. Tuesday, 9:47 a.m. Here's what happened. Judge Arthur Engoron signed emergency turnover order. Motion granted, immediate enforcement authorized. Courtroom quiet. What followed? A G's office transmitted FR 2046 notifications to Federal Reserve. Federal Reserve flagged accounts through FedWire. Banks received compliance notices. 73 minutes, that fast. Now, what everyone missed. While people focused on the dollar amount, something else happened. A G's office simultaneously filed UCC1 financing statements in Delaware, Florida, and New York. UCC1s are public notices of security interests. Think of them like liens. Then filed corresponding notices with county clerks in Palm Beach, Westchester, and New York County. Judge Engoron's response? Approved supplemental asset discovery. Wasn't reactive, calculated. You can see it in the coordinated timing. Court order at 9:47 a.m., federal notifications by 10:15 a.m., UCC filings by 11:30 a.m. They had this ready, just waiting for signature. This is where it gets interesting. Those UCC1 filings, they don't just freeze current assets. They create priority creditor status for anything Trump acquires moving forward. Buys new property? Lien attaches automatically. Receives business income? Subject to garnishment. It's a financial perimeter. And here's the piece nobody caught. One of the UCC1 filings lists future rents and revenues from properties including Trump Tower commercial spaces. Trump Tower generates approximately $20 million annually in commercial rent. That income stream, now potentially subject to diversion to satisfy judgment. Not seizing the building, seizing the cash flow. Different mechanism, way more effective for ongoing collection. The AG's office didn't just freeze $180 million. They built infrastructure to collect from Trump Organization earnings indefinitely until judgment satisfied. That's not a freeze, that's a system. Don't go anywhere. What I show next changes the picture. This affects more than Trump. What are experts saying? Former Assistant U.S. Attorney Jennifer Rogers, 18 years prosecuting financial crimes. This is textbook aggressive collection, rare to see but legally sound. Plain English, unusual but allowed. Another one, Columbia law professor Eric Talley, specializing in commercial litigation. The UCC1 strategy transforms a static judgment into a dynamic collection mechanism. Key there, it's not about the frozen accounts, it's about the system they built. Here's what's interesting. Even constitutional law professor Jonathan Turley, frequent Trump defender, admits the legal framework being used is established law, even if the application is unprecedented in scale. When both sides agree, pay attention. Consensus. The mechanisms are legal. The scale is unusual. The timing raises questions, but doesn't invalidate process. That's where professionals land. Now, former New York State banking superintendent Maria Vullo offered context. Federal Reserve enforcement protocols exist precisely for judgments of this magnitude. Banks have no discretion once FR 2046 notice received. Translation: once that Federal Reserve notification hits, banks must comply, not optional. Banking attorney Helen Cantwell's 30 years structuring asset protection. The sweep account targeting shows sophisticated understanding of how high net worth individuals maintain liquidity. They knew exactly what they were doing. What's notable, I couldn't find a credentialed financial enforcement expert who said the procedures were improper. Aggressive? Yes. Unusual? Absolutely. Improper? That's where professional consensus breaks. Even skeptics of the underlying fraud case acknowledge the collection mechanisms follow established protocols. The debate isn't whether they can do this, it's whether they should, given bond already posted and appeals pending. Legal question: yes, they can. Policy question: reasonable people disagree. Useful breakdown? Like it. Helps this reach people who need context, not just headlines. Why should you care? Real talk, how this affects actual people. Money. If you own property or run a business in New York, pay attention. These enforcement mechanisms apply to any civil judgment over $100,000, not just Trump. Your wallet. Creditor wins judgment against you, they can potentially use same Federal Reserve notification system. Numbers. New York courts issued 47,000 civil judgments exceeding $100,000 last year. What's some business owners doing? Restructuring to limit assets in New York-based accounts. Not advice, just what I'm seeing from accountants I talk to. Precedent. This sets a precedent. Next time you're sued, business dispute, contract disagreement, whatever, rules changed. Quick example, you run a small business, vendor sues you, claims breach of contract, wins a $150,000 judgment. You appeal. Old framework, post bond, appeal proceeds, life continues. New precedent, creditor petitions for asset freeze using procedures established in this case. Your operating accounts locked while appeal pending. Not dramatic, that's how this works now. Who's affected? Right now, 340 plus Trump Organization employees dealing with delayed payments. Vendors in Florida, New York, and New Jersey reporting payment processing issues. Hits within 2 to 3 business days typically. Payroll still processing, different account structure, but operational expenses frozen. What nobody wants to say. Uncomfortable part. If you think political opponents should face maximum legal pressure, you'll support this. If you think defendants deserve protection during appeals, regardless of politics, you'll oppose it. If you run a business or own significant assets, you're part of this, whether you like Trump or not. Not trying to scare you, that's what documents suggest. The enforcement infrastructure built here becomes template for future high-value collection cases. Doesn't matter if defendant is politician, CEO, celebrity, or regular business owner, mechanism now established. Practical. What informed business owners doing? Reviewing asset protection structures with qualified attorneys, understanding which states offer stronger appeal protections, asking accountants about sweep account vulnerabilities. Knowledge helps. Again, not legal advice. Talk to licensed professionals in your jurisdiction. But understanding that civil judgments in New York now carry enhanced enforcement risk, that's just reality. Your business insurance might not cover judgment enforcement costs during appeals. Check your policy. Your operating capital could face freeze if you lose civil case, even while appealing. Structure accordingly. These aren't Trump-specific vulnerabilities. They're general business risks that this case just highlighted. The difference: most of us first learned these mechanisms existed when they got used against someone famous. They existed before, just nobody paid attention. How'd Trump respond? Made it worse. Honestly, held press conference Tuesday afternoon, called it election interference and communism. Quote, "They're trying to take everything before the election so I can't campaign." Reaction? Campaign fundraising emails sent to 4.7 million supporters within hours. Social media posts about financial persecution shared 890,000 plus times. Legal team came back different angle, filed emergency motion with appellate division arguing freeze violates New York's own precedent, requiring imminent dissipation risk before asset seizure during appeals. Counter from AG's office. Defendant has history of moving assets between entities to avoid obligations. Then Tuesday evening development. Trump's lawyers submitted evidence of $400+ million in liquid assets available to satisfy judgment if appeals fail. Argument: why freeze operational accounts when defendant demonstrably solvent? Not cooling down, heating up. AG's office filed response claiming those assets held in trusts not readily accessible for judgment collection. Back and forth continues, each filing more detailed than last. Judge Engoron scheduled hearing for next week to address emergency stay motion. Both sides preparing, media coverage intensifying. Meanwhile, those accounts still frozen. Trump Organization still operating, but clearly constrained. What's still unclear? 1. Whether appellate division grants emergency stay, lifting freeze. 2. How Trump Organization maintains operations if freeze extends beyond 30 days. Coming. Appellate division has emergency hearing scheduled Monday, July 6th. Trump's legal team reportedly preparing extensive brief on constitutional implications. AG's office preparing counter brief defending enforcement necessity. Date to watch Wednesday, July 8th. That's deadline for appellate division ruling on emergency stay motion. If stay granted, freeze lifts pending full appeal. If stay denied, freeze continues potentially 8 to 14 months until appeal resolves. Also monitoring, Trump's accounting team supposedly preparing detailed asset disclosure showing liquidity sufficient to pay judgment. Could change calculation. Another factor, Federal Election Commission filings due July 15th. Will show whether campaign operations affected by organizational financial constraints. Separate issue legally, but politically connected. Should know more by then. Between now and next Wednesday, expect more filings. Both sides lawyering hard. Outcome not predetermined. Subscribe. I'll cover the update when Monday's hearing happens. Breaking down the legal arguments both sides will present. Where we are right now, $180 million across multiple accounts, frozen since Tuesday. Trump Organization operating under constraints, payroll still processing. Emergency stay motion pending before appellate division, scheduled Monday, July 6th. Emergency hearing on asset freeze. Wednesday, July 8th, deadline for appellate division ruling. July 15th, FEC filings due showing financial status. Not public yet whether Trump Organization filed for line of credit to cover operational shortfall. Banks would be hesitant given judgment and freeze, but not impossible. Also unknown, full scope of accounts affected. Yesterday's filing listed 8, but references additional accounts under investigation. Could be more freezes coming. AG's office has subpoena power for financial records, likely reviewing all Trump Organization banking relationships, clocks running on multiple fronts, appeals on underlying fraud case, emergency stay on asset freeze, potential additional enforcement actions, each operating on different timeline. Next major milestone, Monday's hearing. That's where we are. Donald Trump, $180 million frozen. Emergency legal motions filed. Campaign continuing despite financial constraints. Surface read, AG using maximum enforcement, Trump calling it political warfare. But the mechanisms being used existed long before this case. They'll exist long after. What we're watching, stress test of New York's civil enforcement system against defendant with resources to fight every step. I'll be watching Monday's hearing, specifically how appellate division balances defendant appeal rights against creditor enforcement rights. Legal question with implications beyond this defendant. Story's not over, still developing. Subscribe for the full picture, not just headlines. When Monday's hearing transcripts drop, I'll break them down. When appellate division rules Wednesday, I'll explain what it means. This case is teaching us all how high-stakes civil enforcement actually works. Whether you support or oppose Trump, understanding the system matters. Talk soon.